I feel like I should read this filing because I feel like everybody else talks about this anyway. So at least I can have my before I see all the dog legal interpretations that go out. Hold on. Yeah, f it, why not? Hold on. Let me grab a drink. Okay, we're doing a 2 Red Bull day. Good luck. Okay, somebody link me the docket. How does hearsay work in Discord messages? Not sure if you can discuss it or not. Hearsay is when you report what somebody else has told you. The reason why you generally don't want hearsay to be used as strong evidence against somebody is because you have no ability to cross-examine or assess the validity of the person making the claim, right? So in the court of law, you ideally have the right to confront an accuser. If somebody comes into court and they're like, oh, I know that this guy is a murderer because John told me that he saw him kill Jane, and John told me that he heard him say that he wanted to kill Jane, and John, right? So let's say a person comes in and reports all that. It's like, okay, well, you heard him say that, and you're saying this to the court now, but is that guy trustworthy? And the guy's like, oh, I don't know. Okay, well, when did the guy hear him say this? Like, was the guy of, was he drunk or anything? Like, oh, I don't know. It's like, okay, well, fuck. If we can't bring in John to actually ask him questions and have him testify to the validity of his statements, because John didn't tell you this under penalty of perjury, right? Then John can say whatever the fuck he wants, right? This is why generally hearsay is not permissible at like trial, basically. Can you explain some of this for Luddites like myself? Yeah, of course. That's what we're here for. This is what we spend all that time reading Supreme Court cases for. So we could be ready to go. How much you want this to be talked about in the sub? Do you want to make a thread? You can make one. So sure, why not make a mega thread if you want. Does this go bottom to top or top to bottom? Okay, so February 18th, the initial case is filed by Jane Doe. Okay, who knows who that is? This is all just standard paperwork stuff, being assigned to a judge, being assigned to a court, all that. All the procedure rules. Plaintiff filed a motion for permission to proceed under pseudonym and for a protective order. Certain cases allow you to sue anonymously. So when you sue anonymously, what that does is, at least as far as I'm concerned, maybe there are other exceptions to this, but it allows you to shield your identity from the public. The judge still knows who you are, and the defendant will know who you are. But generally, the filings won't have any of the names on them, and then the defendant is usually enjoined from mentioning who the person is specifically in public because it's to protect the identity of the person suing. So generally, you have obviously in cases of like revenge porn would be an obvious one where if a woman were to sue somebody or a man were to sue somebody and they've got their name plastered all over everything, well, that kind of defeats the purpose of filing the case. I think there might be protective orders for children as well to keep their names out of documents, but I'm not 100% sure on that. But more stuff. When a complaint is filed against you, sorry, hold on. We're just gonna run through this up to my response so far because it's just there's so much bad legal shit from supposedly lawyers that I've heard people talk about. Somebody said, didn't she publicly announce she was suing you though? Yeah, it's the way that they did the protection order on this is very fucking weird. I asked about challenging it, but apparently that would just make you look bad to a judge. But I mean, it's the way that they've done it is really goofy. But what I mean, it's whatever. What was I gonna say? Where were we? Fuck, I was gonna say something right before that. I don't remember now. Whatever. Oh. Once a complaint is filed against you, once you've been served the paperwork, meaning somebody's officially handed you the paperwork or they have presented the paperwork to somebody, once they presented the paperwork to somebody who is authorized to accept service, so like for businesses, you can have a person who's authorized to accept service on behalf of the business, etc. You have, I think, a 21-day counter from there to file a response. A lot of people were theorizing that I didn't have any lawyers and I was going to do all of this pro se. And then other people were theorizing that I didn't have lawyers initially because I lied about them for my first case and that I was struggling or scrambling to find some for this later on. Anybody assuming any of this or saying any of this is just a totally baseless assumption. It was fucking retarded. The initial lawyers that I had, a law firm that I was working with up in New York, they were it was like a plaintiff law firm. So there were people that sued on behalf of people that had been victims of revenge porn. That was the litigation firm that I initially retained up in New York, but they specialize in plaintiff cases. They don't specialize, or actually, I don't even know if they do defendant cases, because usually you build a reputation and you practice a particular area of law representing a certain type of person. Sometimes people will work on both sides of that. It's very common that people will work on one side of that and be more specialized. So after Pixie announced her suit against me, I retained a different law firm on recommendation from my New York one, California, and those are the people that I have defending me now. This pro hac vice moment or motion is them filing in order to be able to appear here since they're registered in California. They filed this motion so that they can appear on behalf of me here. And then I have to retain a third law firm, although that's a minor one, in Florida, because you have to have that law firm make the first appearance in order to file the motion for pro hac vice in order for your defense from another state to show up. Okay, Jesus, there you go. But these guys came in. I think we filed our response within 21 days. There's no rush to file a response. I don't know why anybody thought there would be or why there needs to be, but file a response. Let's see, when did the first meme thing happen here? These are all just lawyers appearing. Scheduling report for setting a date for trial, which is like a year out or something. Okay, the first meme thing. On April 3rd, their litigation firm filed for a temporary restraining order. So we've seen these pop up in our Supreme Court stuff. TRO is the exact same thing that it is in the Supreme Court. Temporary restraining order basically means that we're claiming that the defense is engaged in behavior that if they're allowed to continue to engage in will cause irreparable harm to us, and we believe that we're likely to succeed on the merits of the case. So we think that you should enjoin their behavior, stop them from doing a particular thing. And so this TRO was filed. Sorry, hold on. So I saw this at YouTube. Somebody said, why didn't you file a motion to dismiss? So I've seen some people say things like, oh, they didn't file a motion to dismiss because they know that they're fucked so much and blah, blah. The reason why there was no motion to dismiss filed is because it's very obvious and very clear that based on the complaint prima facie satisfies the elements of what they've alleged in the causes of action. So it would have survived a motion to dismiss 1 trillion%. There would be no point in filing. It would literally be just a waste of money. I don't know why I would waste money having them write up a pointless motion to dismiss. Does this? Oh, nice. So on their temporary restraining order against me, I think the requested stuff that they had was, let's see. This is fucking wild. There's actually so much of this is so gross, but whatever. Publication of private messages, severe emotional distress, pattern of behavior of recklessly sharing intimate images without authorization based. They also copy paste things like right from Kiwi Farms or DGG Snark too, which is very fucking funny, but. Lionel's retaliation against plaintiff and other women who dare to go public about his illicit and unauthorized sharing of intimate images, wanton destruction of evidence. Okay. All right. So these are the things that they were talking about in their TRO. Okay. So a couple of big problems. So first of all, publication of private messages is not really a thing that I think is at issue here. Like maybe it could be, but one of the big issues is before the other party sued me, the other party decided to post a massive write-up publicly, accusing me of a whole bunch of stuff and putting a whole bunch of statements out publicly that probably entitles me to have some right of response to it. Somebody asked earlier about the protective order being filed. It is very goofy that you would make a public statement connecting you to the lawsuit and to everything that's happened, and then to, after filing the protective order, try to enjoin me from talking about this in any way, size, shape, or form in any public manner. So that's that part is goofy. The severe emotional distress part is also a little bit goofy. I kind of talked about these before any filings happened, but as much as people don't like this, and as much as people, like to type and say dumb shit on streams about how, like, well, if you make one mistake, every single thing that happens past that mistake is 100% the fault of the person who made the mistake. In the legal world, that's not true. And in no world is that really true. And intuitively, we don't necessarily feel like that. So there are concepts like foreseeability. There are concepts like proximate harm. And the issue is that if you're claiming that there might be like severe harm or severe emotional distress relating to a thing, you severely undermine your claim if you are doing things to exacerbate your damage. So for instance, let's say that you say, this person calling me a racial slur and telling all of their friends they call me a racial slur really bothers me. Let's say that you tweet out like that image of them calling you a racial slur and the whole world sees it. And you're like, look at how much harm this is causing. This is terrible. And then you go to a court and you say, I need to file a temporary restraining order enjoining him from telling anybody about the racial slur he called me. A judge will look at that and they'll go, okay, well, didn't you like publicize the fuck out of this? Like, aren't you kind of also damaging yourself? That would seem to counter the idea that, it would seem to go against the idea that there's some irreparable harm occurring here if you're the one that is also engaged in irreparably harming yourself. So this is a little bit goofy. One thing that they do a lot in this case that's like really goofy as well, but this is what I mean when I say a lot of this is kind of like Redditor tier stuff. So when they want to invoke like other women or when they want to invoke other scenarios, those people aren't part of this lawsuit, and those videos, images, whatever else is being up is not a part of this complaint. It has no bearing on any part of this, and randomly just dumping a ton of stuff into a court case that is totally irrelevant doesn't further any part of your case. Maybe if you're making like a YouTube video hit piece or something, or maybe if it was like a class action lawsuit, or if there were multiple plaintiffs that were named in the case, then you would have an argument to bring stuff like that up. But it's otherwise just like saying like, oh, look at this and that and that and that and that. It's like, well, we're not on trial for that. None of that is like part of the, there's not like a legal pattern or a legal record or anything here that you can invoke. So it's pretty goofy. Real quick, is the transcript for the hearing on this on the docket yet or no? Oh, wait, hold on. I bought a Pacer account for this, so. Oh, shit. Okay, nice. All right. Do you think this is a tactic they use because you're a public figure and they can apply pressure on you? Kinda, but the problem is she applied pressure in all the wrong ways. The problem is that a lot of this was like very amateurish from the start. The lawyers that she hired just aren't very good. I heard through the grapevine that Lauren De Laguna recommended this law firm to her, but it's just kind of like it's kind of, I said this before, like when you go to like Cheesecake Factory, if you go to a restaurant and there's like a menu that has like 1,000 million pieces of, or like 1,000 items on the menu, they probably don't serve anything that good. This was just kind of like a general law firm that just did a lot of random stuff. I don't think they usually handle cases like this. They've certainly never litigated a case like this before. So yeah. Somebody said, could it not work as demonstrating past behavior or character evidence? No, you don't get to do that in court because I'm not, the problem is that you can't bring up a whole bunch of stuff like this that I haven't had the chance. It hasn't been litigated before, and who knows if it's true or not. You're just alleging it in a thing, and it's not even about you. You don't have the right to do that. Again, maybe this works like on a epic Reddit post or something, but in court I can't be like, oh yeah, well this person that guy said that about them, and that guy said that about them. This is like double or triple hearsay even. It's like you're saying what another person said happened to another person. You're so far away from anything like even remotely relevant to any of this. So yeah. When I say went about this in all the wrong ways, what I mean is that the problem is that if we were ever, this is why I said I'm probably never settling anything relating to this case. The problem is that when Pixie made her public post, she basically nuked me as hard as possible. Like the statute that she originally cites has a statutory cap on damages of 150K. And when she made that public post, I incurred I incurred at least 2x as much damage as the maximum statutory payout would be for that. So once she makes that statement publicly, there's basically no incentive for me to settle anything. It's like, okay, well, you've already basically done everything. Whereas usually you would settle prior to a lawsuit to avoid a lawsuit being launched, because obviously a lawsuit being launched is a bunch of bad PR. But if you're gonna make the statement, then I basically have there's no world where I'm settling pretrial. We tried to go back and forth. No, I'm sorry, there was no back and forth. Their counsel spoke to my counsel a few times pre-trial, but their requests for a payoff were just unbelievable. The figure that they came with was $15 million. My counteroffer was no. How about I pay you nothing and you can keep the bullshit that you raised on the GoFundMe, and then maybe we negotiate from there. I don't know. And then after that, they didn't respond with a single counteroffer, and they just 10 days later decided to file a suit. It's like, okay, well, based. Yeah, so this is, I don't know if this shows up in, this might show up in RPI. This is stuff that's like very, very, very gross and very disgusting. And I think that, hopefully this plays against them. I don't know. I don't think this will go past the preliminary stages, but we'll see. Hopefully, we'll see, I guess. But the fact that she filed under a protective order to hide her name, but then uses the full name of my ex-wife, the names of other people, and then names specific websites that you can search to find videos, most of which aren't even the ones that are the subject of this complaint, in my mind is insanely fucking disgusting. I don't know why the fuck you would ever do this. It's very, very, very annoying and very irritating. And assuming there are multiple victims of the original leak where everything was published, I don't know why, if you felt it was so important to file under a protective order for your name, when you've already publicized your involvement in this, why you would put other people's names who aren't the subject of our lawsuit, because none of these people are plaintiffs, none of these people are signed onto this case with her. Why would you throw their shit on there and then start linking websites? That's fucking crazy to me. But whatever. I feel like it's especially egregious. They even throw like Denham's accusations in here, but I ended up sending the full audio between me, Denham's, and another person to Willie, and he played some of that. So apparently this got addressed, at least on Willie Mac's video. They talk about retaliation against plaintiff and other women. So the retaliation is just me talking to my chat about how I think it's a smear campaign. I think they want money, but I mean, like, I'm allowed to say that, but why do they call you Destiny this? They call me Destiny Bono. They call me all sorts of this. It's fucking dumb. Again, they bring up other people who aren't even the subject of this complaint. Cherry, Denham's, none of these people have anything to do with this lawsuit. They have nothing to do with anything. I don't know why they're brought up. This claim gets thrown around a lot. Some of it originates, I think, from Pixie herself and maybe her group of friends. And I've seen other people post about this, about destruction of evidence. So when you sue somebody, when you go to court, or when you're made aware that a lawsuit is possible, what you have is an obligation on both parties to preserve evidence that might be relevant for the court case. So if somebody says, I'm going to sue you because I think you sent a whole bunch of stuff to, party X, you can't start deleting everything with party X. You're not allowed to do that to destroy the evidence, so that when they get sued, there's a process after your pleading stage called the discovery phase. And discovery is where you can say, hey, I want you to send me documents of this or that, or I want you to show me like, what you said of this, and you have the right to request those documents from the other party. If you've destroyed all of the evidence of that, or if you've destroyed all of the logs of that, that's called spoliation. And spoliation means that you've spoiled, you've destroyed evidence, and you can get sanctioned in a case for that, such that what a judge will say is, okay, well, she said that you told X that you thought she was an N-word, and we see you've deleted all the logs. Well, when this comes up in court, when I'm considering things for motions, or when the jury's considering things, they're allowed to consider that disfavorably. That's not going to be a thing where they'll be like, well, you can't consider any of the messages there because we don't have them. What the judge would tell the jury is, you're allowed to assume whatever you want, and you can think negatively about them if you want, because this was intentionally hidden by the defense, okay? I have not destroyed any evidence whatsoever. I do not have an obligation to keep public all of my messages, especially to people, and there have been multiple people now that have just started dumping entire chat histories with me. There is zero obligation that I have to keep those messages accessible to them on Discord. I received a request to back up stuff on January 23rd, I believe, and I have backed up all the conversations. I've backed everything up I've needed to. I have no obligation whatsoever to keep those available on any other platform. And the idea that I've engaged in destruction of evidence is especially weird because the other party has not requested any discovery from us yet. They haven't even made a request for documentation. So how could you possibly even know that I've destroyed any evidence when you haven't even requested any copies of anything yet? So it's dumb. Especially when you've got other people like, so a streamer person by this, another person by this messaged Pixie and said that their messages were deleted. These aren't even the subject of the lawsuit. This has nothing to do with any of this. But yeah, so it's just so much random shit and garbage. So the relief they were requesting was, let me see if it's plainly stated. So this is the behavior they were trying to enjoin from me. So enjoin means to stop a thing to stop me from behaving in a certain way. So one was enjoining me from sharing, publishing, or transmitting, whether directly or indirectly, the videos and or private messages. So they wanted me to take down my response document that I made because some of our messages were in there. The videos thing is ridiculous because I'm not sharing, publishing, or transmitting any of this, and none of the other websites where it's actually being shared at are listed as defendants or anything in this document, so I have no control over any of that. Two was compelling him to remove all publication of plaintiff's private message and private information from all forms of public media he controls, either directly or indirectly. So this was telling me to take down basically all of my responses to her public statement about me. And then three, ordering defendant to cease and desist from destroying evidence and compelling defendant to retrieve all messages that he deleted and preserve all discoverable evidence that is in any way related to this case or that could prove any non-consensual disclosures from his phones, computers, tablets, blah, blah. So this is dumb because you're already supposed to do this. Like, why would you ask for a temporary restraining order where you're already, this is like already what you're supposed to do, and they haven't demonstrated that I've like violated this at all. So, and then four was compel defendant to direct third parties, including Kiwi Farms and all of these other websites where you can just type in my shit and go find all of my fucking porn videos, I guess, and social media accounts in writing to comply with this order by removing any version of the video containing plaintiff's image and likeness from any form of public media under control. First of all, I've already done this on some of these. Secondly, you can do this just as much as I can, so I don't know why this would even be on me to do this. Thirdly, depending on the website, I have a worse chance of getting something taken down than she does. So I don't know why she would try to compel me to do this. And then five, compelling defendant to attest in a declaration that he has complied with this court's order and describe the steps he's taken to do so. Okay. So a couple other memes. Okay. So typically in a trial setting, okay, the court has a very limited amount of time. Okay. Jessica kept saying he has knowledge of this when you responded, but I think it's technical wording. Lacks knowledge means different in law. No, I don't even know. Most of the other people, people talking about this are fucking retarded. Okay. Court's time is pretty valuable. You don't want to waste court's time. What does that usually mean? That usually means what you try to do is you want people to talk outside of court as much as possible. So legal teams should meet, confer with each other, try to figure out before anything's filed with the court, hey, is there a thing we can work out here? You know, is there a thing, can you guys stop doing this? So like, let's say, for instance, you genuinely wanted some behavior to stop. Ideally, as long as the parties are, the counsel is at least communicating with each other, you say like, hey, can you not do this? Can we make this agreement? We can file this as a joint motion with the court. We can agree, you know, whatever. That's typically it's what you do. Or if you're going to file a motion against somebody, you know, you're giving them a heads up. Here's a copy of this. We're going to file this to request the court to you know, post this motion, basically. The my legal team and their legal team had a meeting for scheduling to schedule how the I think it's like scheduling like the trial date and everything. That meeting went no problem, and then the next day they filed this temporary restraining order, which was like, so with no heads up, no warning, no anything, they were just like, oh, by the way, boom, we see that TRO gets filed with court. It's like, okay, that's weird for a few reasons. The first reason that's weird is that why the fuck did we have no heads up of this? Like, why are you ambushing us with a TRO? Because you know we're gonna have to file for an extension, and you could have just said something while we were in this meeting. You know, potentially we could have worked some of this up beforehand. That's ridiculous. Number one, and number two, why would you file a TRO like 2 months after the case has been filed? Remember, again, this is the same standard basically that we're talking about for the Supreme Court cases. When a temporary restraining order is filed, you're saying that I'm being harmed so much that if it continues, I can't be made whole again. I'm fucked, okay? I need the court. I'm begging the court to please enjoin the defendant, stop the defendant from engaging in this behavior that I'm suing them over. Please, I need you to stop this. It's insanely harmful. So to file a court case against somebody, but then to wait 2 months to file a TRO by surprise is just kind of extraordinary. And then obviously the stuff that's being requested in here is just kind of goofy. So everything about this is just kind of silly, but oh, and then it also sucks because remember, the main law firm that's representing me isn't the Florida one that I need for some of the filings. It's a California law firm. And for some of these things, you have to appear in person. So they file a TRO. The judge is going out of town in like 3 days. So I think the judge schedules an emergency meeting to hear an emergency hearing for the TRO like the next day. So my counsel has to appear by Zoom, okay, long distance, which this judge doesn't like. Because it's a TRO, it's an emergency. You're begging for, like, please do something, like this is really bad. And then this is the transcript of that hearing. For the courtroom deputy, counsel, please state your appearance for the record, starting with the plaintiffs that are present in the courtroom, defendant present in the courtroom, and then the parties on Zoom. Ms. Schlump, I believe that's their lawyer. Good afternoon, Your Honor. Joan Peters, Schlump, on behalf of the plaintiff. I think these are all their... wait. These two are theirs, and then these two are my guys. Garcia Perez, good afternoon, Your Honor. Carlos Garcia Perez, on behalf of the plaintiff. And then... oh, yeah, it says it here, yeah. Robert, on behalf of the defendant, and Andrew, on behalf of the defendant. And then other... on behalf of the defendant. Okay. The court asks, oh, this is my, I think, from the Florida law firm, I think, the Miami one. Are you in the Miami office? Ms. Bettina says, I am. I'm just not in Miami at the moment. The court, the judge, I don't like Zoom hearings. Everyone can be seated. I only allow counsel that are out of town. I just don't want to give anybody a misimpression about when I allow Zoom hearings. You could be seated, counsel. Mr. Raskoff, thank you, Your Honor. So this case has been pending for a number of months. You looked at me a little cockeyed, ma'am. Didn't you file it a couple months ago? There, Ms. Schlump, February 21st, I believe. Yes. Yes, correct. It's April, so it's been filed. The parties have already met for the joint status report. That was already filed. I've got a scheduling order. The defendants have answered. And now, last night, I get a TRO based on facts that don't appear to be any different from the complaint. So I want to hear, just very briefly, as to why I should entertain the TRO as opposed to just setting it down for a preliminary injunction. So a preliminary injunction is basically the same thing as a TRO, except the preliminary injunction will last for the entire trial. A TRO is just like saying, hey, I need this to stop immediately. A preliminary injunction is saying, hey, I need this behavior to stop until the end of the trial. So a TRO, you can file it, and then that kind of rolls into a preliminary injunction hearing. And then if it's granted, then the defense is enjoined from that behavior until the case ends. Or if it's denied, then it's tossed out. Okay, so the judge is saying, why is this being filed as a TRO as opposed to just setting it down for a preliminary injunction hearing, preliminary injunction? Plaintiffs say, well, Your Honor, I do apologize for the delay in getting that motion out. There are a number of reasons why that happened. One, and I hate to go into personal things, but Mr. Garcia was dealing with a cancer issue and going back and forth to Texas. I had pneumonia, and I was out straight for more than 2 weeks, so we were really set back. There's just 2 of us working on this case, and so that significantly delayed us. But there's also other reasons, which is that we were trying to gather affidavits from witnesses to bolster our evidence for the TRO and get, witnesses lined up for it. So again, I don't know why you don't have all of this in line before filing your case against me. She was planning it for at least 2 weeks is when DMs leaked between her and Aaron for making that public Substack post. And then it was a month after between that and the complaint to where she waited for that. So I don't know why. I have no idea how they don't have this already, but okay. Unfortunately, what we have encountered, we have a number of women that have come forward to us, but have then backed out because they are afraid of retaliation. And that's what they've told us. And so we were not able to get these affidavits. Okay. We went with what we have now, which basically we went from 15 potential witnesses providing evidence down to the 1 witness in addition to the plaintiff. Okay. The court says that doesn't have anything to do with anything. Thank you, dude. Okay. I'm going to be honest, okay? Because as much as people say this, all right, as much as people say shit, I really do worry that I think too much of my knowledge in any particular area. Even though I try to check myself, I worry, like, am I getting lost in the sauce, or am I overestimating my competency or overestimating what I know in some things? Okay, when I read the complaint and then when I read the TRO, I'm like, this looks fucking stupid as fuck. Like, I don't understand why you can bring up so much shit that's not even relevant to any part of, like, what this case. But maybe for civil cases, maybe it's different. Maybe in federal cases, it's different. Maybe for these types of cases, it's different. Maybe there's just some shit that I just don't know. And listening to the judge talk to the other opposing party in this is, oh my God, it just made me feel so much saner. I was like, oh God, okay, thank you. Jesus. But okay, that doesn't have anything to do with anything. This is not a class action. You filed on behalf of 1 woman. The TRO requests that he remove the video of the 1 woman, and then there is a request with respect to whether or not he's doing anything to destroy evidence in this case. I don't know that that's a TRO. I think that's more akin. You can file a motion with respect to that. None of this sounds in a TRO to me. So you can file a motion to compel people to do things. Motions are just like it's like a turn in an RPG or like a board game. Like before you actually go to trial, you take a turn and you ask, can you do this or can you do that, or we're going to do this or we're going to do that. A TRO is like before you've even started the game. You're like, I need this done or shit is going to be fucked. Please, we need to do this. I really have to go to the bathroom, whatever, right? So she's saying this doesn't sound like it needs to be part of a temporary restraining order, a TRO, part of a like this. This sounds like it could be something completely different, right? Obviously, the medical issue, I hope you're doing better. They say, thank you, the court. I hope it's not obviously more than a short delay on a case. But I don't see the emergency nature of the TRO. This seems to me, at best, a preliminary injunction. There's nothing that's happening today that wasn't happening when you filed the suit or even a month before, right? In fact, if anything, like the dates seem to line up sometime at the end of the year, right? I'm in April. I don't see why the request for a TRO is not stale. So I think that, now I don't know specifically what this means, but I think when people say something is stale, what they mean is that if you, if you've waited too long to do something, it undermines the key argument for you arguing for the thing. Like imagine if I were to, imagine if I could make an emergency request for oxygen instead of a normal request for oxygen. Imagine I can make an emergency request for oxygen if I'm in like a submarine. And imagine that I go underneath the water and then I file an emergency request for oxygen like 2 months later and I say, we need oxygen. We don't have any oxygen down here. Well, they would look at that and they go, hold on, you've been down there for 2 months and you didn't go down with the, this is stale. This is not appropriate. Something else is like, this is just not, doesn't make any sense, right? So when you say something's stale, like the time has passed for this to be an appropriate remedy for what you're seeking, because the fact that you've waited so long undermines the entire purpose of the thing. They might go into it later in another motion, but there's like elements for a TRO, and one is showing like the appropriate, like you have to file it in a certain time for it to be appropriate. Let me get a drink of water. I feel like my throat is hoarse for some reason. Okay. Okay, I'm in April, and I don't see why the request for a TRO is not stale. Miss Schlump, I understand your concerns, Your Honor, and that is why we didn't file it as an emergency TRO. I've never heard of that before, but again, I'm not a lawyer, so maybe I don't know what the difference is between an emergency TRO and a TRO period. I thought all TROs were emergency. Maybe that is a real thing, I'm not sure, but I agree that most of the damage has already been done, but the issue is that we keep receiving evidence of destruction of evidence. We are trying to compile enough evidence to file a motion for spoliation because we are very concerned with the fact that all of this evidence is disappearing. So we are hoping to file that very shortly. We're waiting for a specific piece of evidence that we wanted to bring before the court. So yes, I agree with you. This is not an urgent matter for having a TRO immediately, but it is ongoing harm that we would like to stop. So again, and I'm not just saying this, I truly do believe there must be something I'm not understanding, because I don't know, a TRO by my understanding is definitionally immediate. You don't file a TRO and then let it sit for a few weeks. A TRO is by definition immediate. And to say that there's a motion that we could have filed instead, but now we filed a TRO, like, you're asking the judge, you're saying we need to make a meeting soon on this. You're imposing on the court's time, like, judge, you have to hear this immediately. This is so fucking important. There has to be a hearing on this. It can't just be something filed. It's like, Jesus Christ. But, yeah. The court responds, that's why a preliminary injunction, I think, is more appropriate. All the TRO is going to get you is 10 days before we get to the preliminary injunction. I don't see the urgent nature. I will tell you that even for my own scheduling purposes, as you might have heard, some of you were here for the other hearing. I am out of the district Monday or Tuesday. I'm here Wednesday, but I start a criminal trial on Thursday that's likely to go for a week. And so my intention was to deny your request for a temporary restraining order, but set a preliminary injunction hearing and refer that, though, to the magistrate judge who has got, he doesn't have my trial schedule, so he can hear the preliminary injunction. Your appearance was waived at this, right? My counsel appeared here. He will issue a report and recommendation on the preliminary injunction, which then I would hear any objection, and I will rule on it as soon as possible. But it seems to me that the harm that you're sounding, as best as I can tell, I might be wrong, but to the extent that we're really talking about the spoliation issue, that seems to me more of a spoliation than a preliminary injunction. But I don't want to get too far ahead of myself. We can handle that as a PI, and it might not even be a preliminary injunction. It might just be an issue on spoliation. And I will tell you that even as you've pled it so far, we'll see what the defense says, but if I got sued for distributing the materials about a woman, and I may have done that with other women, then I might say to myself, maybe I shouldn't do that anymore. Let me delete that. Let me take that back. Let me not do these things I'm being alleged that I'm doing, because maybe these are bad things I shouldn't be doing. That may be one of the things that's going on. That's not spoliation. I don't know. So a kind of extra funny thing is I received a request for a preservation of evidence from them, but I also received a cease and desist telling me to delete stuff as well. So it is funny that without the judge even knowing that she basically picked up that, like, yeah, you can have both of these. But, okay. Some of the stuff that's in this motion, I'm not finding on its face what the connection is to this case. I assume you will make that argument to Judge Torres and connect it up how it's connected to this case, because some of that, I don't know, is a spoliation issue even, right? At least how you've pled it so far, or how you've argued it so far. So I called you in for the status because I didn't know if there was something else that was happening with respect to the timing for the TRO. I am assuming that you've also been talking to counsel because you were together for the joint scheduling report. Correct. And then Andrew says, my lawyer, sorry, Your Honor, we were shocked to hear about this. And then the judge responds, sir, I'm talking to counsel for plaintiff. I will get to you. And then she talks back to Joanne, I think, their counsel. So you were definitely together for the joint scheduling report. They respond, yes and no, we did not discuss a motion for TRO during the joint scheduling. We just discussed scheduling. I would say, Your Honor, that I understand what you're saying about the spoliation, but one of the reasons that we were moving for the TRO is because I do think that the defendant is destroying evidence, and so we were looking for an order asking him to respect the preservation of evidence rules. And we had sent him a letter before the complaint was even filed asking him to preserve evidence. I mean, he has even deleted messages between him and the plaintiff. That, to me, is destruction of evidence that's relevant to this case. The judge says, we're getting way ahead of ourselves, right? She responds, well, so that was one of the reliefs that we were seeking in the motion. We just want, was just that he be ordered to preserve and not delete any further evidence. The judge responds, so I don't even think that's subject to the TRO, and I'll tell you why. You have both a preservation letter, plus a complaint, plus a scheduling order. If the defendant, after having notice of the suit, is destroying evidence, I mean, he's also got lawyers who I am sure are advising him of what he can and can't do. If I were to find, or if Judge Torres finds as part of a discovery issue that he has destroyed evidence, well, there's all sorts of remedies that the court can take to do that. So that has to do with what I was saying earlier, is that they could say, hey, you're deleting shit, like the jury's going to hold this against you, basically, you know? Yeah. Shouldn't they have already gathered whatever evidence that you were supposedly deleting? They're just screenshots. No, you're not. Yeah, the problem is they don't have anything, but that's always just my opinion, but whatever. There's all sorts of remedies that the court can take to do that. The order that you're seeking requires him to do nothing more than he's already required to do, because he can't destroy evidence now, right? You can't destroy evidence after you're on notice of the suit and the preservation letter has been sent. So if he is in fact destroying evidence, he can't do that. If he doesn't think he's destroying evidence for some reason, well, that will all play out either in a motion for spoliation or maybe in the preliminary injunction. But to issue a temporary restraining order now on some sort of urgent basis, one, I think that it's stale because even that has been going on for some time. That's not something that you found out right now and I need to stop it right now. They replied, right. She says, so I'm going to deny your motion for a TRO. I know I just set it for status, but I don't want to have to set the TRO for Wednesday to tell you what I'm telling you now, because I don't think, I've read your papers, and I think based on your papers, the TRO is stale. But unless I hear an objection from you, not that your objection would necessarily change my mind, but I'm going to let you put the objection on the record if you have one, but I will deny your TRO and set you to go to the judge, to Judge Torres, to have him set the hearing for the preliminary injunction. She responds, we have no objection, Your Honor. All right. And the judge says, all right, now, sir, I can hear from you. And then my lawyer responds, I'm sorry, Your Honor, with the court's ruling right now, I don't think that there is any reason for us to argue any further. I will point out no one is destroying evidence. I will further point out that we had no meet and confer efforts with plaintiff's counsel about this. We were stunned to see not only one, but two motions it looked like for a TRO filed yesterday. And I understand that counsel did say that they didn't file it as an emergency TRO, but by its very nature, TROs are an emergency, seeking emergency relief. This is my understanding. I don't know what an emergency TRO is, but okay. We agree with the court's assessment. Oh, it sounds like he's saying maybe there is an emergency TRO. Maybe there's like a normal TRO, and emergency TRO is like, I need a hearing tonight or tomorrow, maybe is the difference, but. We agree with the court's assessment and have no objection to having this referred to the magistrate for the PI hearing. PI is the preliminary injunction. The court says, so there were two TROs, but I thought the second one essentially amended the first. There wasn't a different recovery. Is that correct? So the other side has also had, for some reason, they have a lot of issues filing paperwork. Like they made, I think their initial discovery request or something, not even that. It was like a declaration thing they filed publicly, which they weren't supposed to do. I think that's hopefully struck from the record. They've been fucking up a lot of their filings. It's very fucking annoying, but their lawyer, she says, our administrative assistant did the filings, and I think what happened was she neglected to include Exhibit 3, and so she refiled. So that was it's the exact same thing. There's not two motions. The judge responds, so I'm going to deny 20 because the motion was the same. It was that exhibit that was different. I will deny 20 because 20 was duplicative as in essence of 21. They reply, yes. The court says, and then 21, I'm going to deny the request for the TRO and for the preliminary injunction to Judge Torres, and that's ECF 21. And then I will leave it to Judge Torres to decide what briefing schedule, if any, he wants to give the defense. He might just set it for hearing, or he might give you an opportunity to brief it. I don't know what Judge Torres will do, but I will give it to him on the preliminary injunction. Let me just say, I don't think that there is, I have to check the local rule on this because I can't cite it from memory, although I probably should be able to. I don't think there is an obligation necessarily for them to confer on the TRO. That being said, and I think that's one of the exceptions to conferral, but I think you're going to agree with me on that, counsel. Yes, I do. I definitely confirmed that before I filed. I confirmed, so they checked to make sure they didn't have to tell us before they filed the TRO. Okay. What a slime ball, dude. The judge responds, I don't think that there is a requirement. That being said, this does strike me as something that you could talk about and say, because even from the evidence that plaintiff has shown, it seems like the defendant, at least with these messages to the plaintiff, is suggesting that he would withdraw the video or try to do things with the video to take it out of the public space. That seems like something you might be able to work out, maybe not, I don't know. And if there is an issue with the destruction of evidence, that's something that on a motion for spoliation, you will have to confer. It seems to me that you should be conferring about this, that it makes most sense, and especially if you want a resolution that's quicker, is to talk about it because you will have to set it for PI. There will be a hearing, there will have to be a written report and recommendation, it will have to come to me. I think you should pick up the phone and talk. Their side has been incredibly, I'll say antagonistic. I don't know if these people are all like friends with each other or what, but it's very, very, very irritating communicating with the other legal team on this, but whatever. I mean, it is a little odd, man. I will just say, if you're sitting talking about the schedule and everything, clearly you were already working on the TRO. Probably the defendant didn't love to get that TRO filed, like the day after you were conferring for an hour on the schedule. It doesn't mean you couldn't do it. It's just that it's not great. Can you explain TROs and PIs real quick? I literally explained this like 10 times. She replies, their lawyer says, I didn't. I hear what you're saying, Your Honor. The judge says, it's not a great way to start a case. Their counsel replies, we have had discussions with counsel prior to this, and they were not very productive, so I did not think that discussing this matter with them. I mean, Mr. Bretler just said his client is not destroying evidence. We know the client is destroying evidence. We've seen it. So it's just not, the judge says, hold on. When I speak, you have to stop. Sorry, go ahead. Yes, sorry. One, not just because I'm the judge, but two, because my court reporter only writes down what one person says, and I promise it's always what I'm saying if there are two people talking. My point to you is that you can tell them your client is destroying evidence. Of course, they're going to tell you that he's not. I would hope they're going to say that. Now, if you show them evidence of it, they're probably not going to say, yeah, he is destroying evidence, but they might talk to their client and come to some agreement with you about what he can and can't do. It's stupid. I'm glad I'm not crazy. It's stupid reading this because this is all like very obvious. If you think somebody is destroying evidence, then obviously you would have that conversation, right? They should be calling my counsel and saying, hey, your client is deleting things that we don't think he has a right to be deleting. Can we talk about this? But they just didn't do that at all. Instead, they just ran to court to file a fucking TRO, for just an insane fucking random thing. It was like, okay, good meme, I guess. They might talk to their client and come to some agreement with you about what he can and can't do. So, productivity isn't them acquiescing to your allegation, but you might be able to get some resolution of what he can and can't do in this space in terms of what he can do with his emails and what he can do with his chats. I mean, there are so many platforms and things now, I don't even try to keep up with them. Even though I have a teenager, and I think I do keep up with them, I don't because there's something new that comes out every day. So whatever platforms he is chatting with people or talking to people on, these things I know are moving targets, but it's always productive to talk. And let me just say one more thing because it's day, not day one, because it's day, not day one because you filed in February, but we're really early on in this litigation that will be before me for God knows how long. You need to confer. They respond, understood. The judge says, and you need to confer a lot. I think good lawyers working in good faith can work a lot of things out. And when you can't, that's my job, and I'm happy to hear disputes. I obviously love it, otherwise I wouldn't want this job, but the dispute is better and it's easier for the court and it's fairer for the parties if what's before the court has really been crystallized by conferral. Sorry. So I hear you that these lawyers aren't going to agree with you, probably on much when it comes to the substance, but it does help to crystallize the issues if you at least talk to each other. And it's very difficult when they've been sitting with you for an hour talking about the schedule and you never mentioned the TRO and it gets filed. It doesn't help in terms of the lawyers trusting each other to at least bring issues in good faith. It's a complex case. I understand, it's a sensitive matter for your client. I understand that. But if we want to go forward in a way that's productive going forward, I'm going to encourage you as best you can to talk to the lawyers. Keep talking to the defense lawyers. And I'm not telling you to agree with them. I'm just telling you to work in good faith to try to bring things to the court when they have been crystallized and when they have been vetted by both sides. I think that only helps the court, and I think it only helps the parties. So, as I said, for purposes of my ruling, I find that the request for a TRO is stale. There is no urgent issue before the court. It can be handled at the preliminary injunction. Because of my court schedule and trial schedule, it will be referred to the magistrate judge. I would expect that by Monday, his chambers will reach out to you by order or by phone or something, or Tuesday to maybe figure out what those dates are and what the scheduling is. All right, anything else on behalf of the plaintiff? They respond, no, Your Honor. The judge says, on behalf of the defendant, my lawyer says, the only thing, Your Honor, is I will absolutely appear in person at future hearings. The only reason I couldn't is because we only had 18 hours notice of this one. Otherwise, I would have been on an airplane and appreciate the court's accommodation. The judge says, look, I missed it because I saw Bilson and I missed that there was an LA lawyer on it. And I just wanted to have it today because I'm out of the district Monday and Tuesday. I didn't want to wait on a TRO, or I didn't want to on a TRO wait till Wednesday. So we just jumped on it at a hearing. I know it's Friday afternoon. It's almost 5 o'clock. Sorry, Miami traffic. Friday afternoon is rough. I wasn't trying to punish anybody. I've just had hearings all day. And so this space I had for you. Thank you. There you go. So that was the transcript for the hearing here, which was goofy. So all of this rolls over into a preliminary injunction request, which is them basically making the same request as what was in the TRO. And then I think our filing was due today. So this is our response to the preliminary injunction request. I don't know when they have to have this responded to by, but the court already denied plaintiff's application for a TRO, finding there was no emergency because plaintiff waited too long to file. The court should deny the remaining motion for a preliminary injunction because plaintiff fails to meet the standard for an injunction and there is no conduct to enjoin. Plaintiff is asking the court to order defendant Bonnell to do things he has already done or is under illegal obligation to do. Moreover, plaintiff is engaged in and continues to engage in the same conduct that she asks the court to prevent Bonnell from doing. Plaintiff has intentionally attracted publicity for this case, including by soliciting public donations to cover her legal fees. Now, her attempt to enjoin Bonnell while simultaneously engaging in the same conduct she wants him to stop is fundamentally unjust. Am I allowed to bring up conversations that we've had between counsel? Am I allowed to? I think I am, right? That's not like, I wouldn't be allowed to say that publicly, right? Where's Leon's law? Or Jen? I think it shows up in other. It's not a huge deal, but like one of the annoying things is that like they're trying to enjoin me from mentioning anything about this publicly. Like they don't want me to be able to talk about it. They want me to take down, like part of their request is for me to take down everything that I've said. They've requested all of that, but they said that they're willing to also take everything down except for they want to leave her Substack up or not the Substack. They want to leave the request for funds up, the donation thing. And it's like, bro, are you serious? Like, you want to dump everything publicly so that everybody else can make a fucking video about everything and then have all those attacks against me. And then you want to file a TRO and enjoin me from being able to talk about it? Are you fucking serious? Yeah, I don't know, bro. It's just fucking, it's goofy, okay? Jesus. But the motion fails as a matter of law because plaintiff cannot demonstrate through admissible evidence that she is entitled to the injunctive relief she requests or that such relief is necessary. As a threshold matter, the court lacks subject matter jurisdiction here. Threshold matter means like does it meet like the bare minimum to do like a thing? Like it has to meet this thing for it to be like considered or whatever, right? Like as a threshold matter, humans have to have DNA or something, right? The court lacks subject matter jurisdiction here. So this case was filed in a federal court because one of the causes of action is referring to a federal law, right? Count 1 of the complaint for violation of 15 U.S.C. Section 6851 is the sole basis for federal question jurisdiction, yet count 1 is fatally flawed because the alleged violation preceded the effective date of the statute by nearly 6 months. So one of the big issues with this is when they filed their case against me, I think they knew that it was out of range for the civil cause of action that they're citing here, but they lied about the date on the DM. They switched the day and the month to try to bring it in range. But the issue is that that's not true. And the issue is that if that message date is wrong, and it is what I say it is, and I know it is what I say it is because I have all the logs, what would happen is the first federal cause of action here, the only federal cause of action, would be invalid. It would be a failure to state a claim. It wouldn't survive a summary judgment. And if you dismiss the first cause of action, then the entire case is dismissed because it falls out of federal jurisdiction. They would have no subject matter jurisdiction on the case. And if they wanted to, they would have to refile in Florida court without the first cause of action. But the other 3 causes of action they've listed are even more ridiculous than the first one. So this is why I'm so fucking irritated by this whole stupid fucking court case. But whatever. Because the statute is not retroactive, the court does not have subject matter jurisdiction over plaintiff's federal claims and should decline to exercise supplemental jurisdiction over the remaining state law claims. Because the court has no jurisdiction to hear this case, plaintiff cannot establish a substantial probability of success on the merits. Critically, even if the court has jurisdiction, it should deny the motion because plaintiff cannot demonstrate irreparable harm. The complaint concerns a single transmission of one video to one individual over 3 years ago. Indeed, at the April 4th, 2025 status conference, Judge Becerra stated succinctly, and then they just quote the transcript from our talk, there's nothing that's happening today that wasn't happening when you filed the suit or even a month before, right? The order that you're seeking requires Bunnell to do nothing more than he's already required to do. There's no urgent issue before the court. Remember, because of who's named on this complaint, it's just me and the opposing party. The only thing that they can really talk about is a video sent to one person. All the public stuff and all of that, they aren't naming anybody else as part of this lawsuit, so none of that is relevant to the lawsuit. You can't bring that in as part of this, even though everybody thinks you can. That's just not how any of this works. But statement of facts: Defendant Bunnell is a live streamer, progressive political commentator, commonly known on Line of Destiny. Plaintiff also is an online streamer who uses the screen name Pixie. Plaintiff and Bunnell met each other. Blah 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 blah. This is just like basic facts, basically so far. I think. Plaintiff and Bunnell met each other online in late 2019. Shortly after meeting, on October 23rd, 2019, plaintiff sent Bunnell a private message and developed a friendship with him. Eventually, plaintiff Bunnell began openly discussing their sex lives with each other, notwithstanding plaintiff's January 3rd, 2025 social media post in which she claimed, "I have never, ever sent videos of other people to Stephen Bunnell ever." On multiple occasions, plaintiff offered to send Bunnell and in fact did send him sexually explicit videos of herself and third parties. For example, on March 17th, 2020, plaintiff messaged Bunnell, "I took some videos of the guy. I can send you later if you're interested. I'll send you when I get them." In that same conversation, she encouraged Bunnell to send her similar videos of himself with third parties. "I won't bet anything you want to send me. I'm a super curious person." Plaintiff on March 19th, 2020, sent Bunnell 4 separate sexually explicit videos of herself engaging in sex, blah, blah, blah. And then there's exhibits for all of this to back all of this up, obviously. In another message from March 19, 2020, plaintiff suggested that she and Bonnell meet in person and make sexually explicit videos together. Would you want to make some videos together? Plaintiff repeated this suggestion on September 6, 2020. Do you want to take videos when we do stuff together? It did, blah, blah, blah. 6 days later, on September 12, 2020, plaintiff and Bonnell met and agreed to record their sexual encounter. At the time, Bonnell was engaged to be married. Bonnell told plaintiff that he and his then fiancée enjoyed watching such videos of each other. Plaintiff did not object to Bonnell showing the video to his then fiancée or to anyone else. Plaintiff's correspondence and the content she previously shared with Bonnell demonstrated to Bonnell that she was comfortable sending explicit videos of herself with other sex partners. In early 2022, Bonnell was contacted on Discord by an individual who used the screen name Rose. They quickly began an online friendship. During their friendship, Bonnell exchanged sexually explicit messages and content with Rose, including the video that he made with plaintiff more than a year earlier. Plaintiff was anonymous, as Bonnell never identified her by her legal name, her screen name, or otherwise. Likewise, Rose never indicated that she recognized plaintiff. Bonnell transmitted the video to Rose, the video on April 9th, 2022. Ooh, typo. And believes that she is the only person to whom he has sent the video. And since that date, Bonnell has not shared or otherwise transmitted the video to any other third party and will not do so, obviously. Over 2 years later, on November 29th, 2024, Bonnell learned that he was a victim of revenge pornography. A number of his communications and sexually explicit videos were published to a website called Kiwi Farms. Bonnell does not know who leaked the unlawfully published online content, but he suspects it was someone with access, whether lawfully or not, to Rose's Discord chats. On the same day that Bonnell discovered the leak, plaintiff contacted him about it. Plaintiff made it clear that she did not want to be identified in the video and wrote that she was 100% denying it's me, since it's not super clear it's my face or anything like that. Within days, and at plaintiff's request, Bonnell took steps to have the video removed from various websites. Among other things, Bonnell retained specialized legal counsel with expertise in revenge pornography matters to assist him in connection with the removal efforts. Bonnell provided plaintiff with updates on his progress. These were all DMs I've shown. Nevertheless, on December 11th, 2024, plaintiff's tone towards Bonnell turned hostile and threatening, prompting him to contact a mutual friend of his and plaintiff to see if there was anything he could do to help further. After speaking with plaintiff, their mutual friend advised Bonnell that he should offer money to plaintiff. Then, on or about January 22nd, 2025, Bonnell received a document preservation demand letter from plaintiff's attorneys. On January 31st, plaintiff's attorneys sent him a follow-up letter demanding that he pay plaintiff $15 million for damages she allegedly incurred and take measures to prevent the further dissemination and or distribution of the video. Upon receipt of the first letter, Bonnell began preserving all documents and correspondence pertaining to plaintiff's purported claims. Here's another exhibit. Contrary to plaintiff's accusations, Bonnell has not permanently deleted or destroyed any evidence pertaining to this lawsuit. In an effort to comply with plaintiff's and her lawyer's demand that Bonnell limit the spread of the video, he deleted files and correspondence, but only after he took adequate steps to preserve all such evidence. Despite claiming that at least 15 potential witnesses contacted her, purporting to have evidence that Bonnell shared the video with them, plaintiff provided only one declaration from a person named Hannah Daniels Brooke, purporting to state as much. I don't know if I included this part in our exhibits here, but the Hannah person also, this has been a massive mindfuck to me because there are others involved in this too that I won't name publicly, but the Hannah person was trying to bait me. I think they deleted some of their messages and what they leaked of mine, but like she was literally on like some, wow, it's so like, I think I talked to this person for about a year. We'd never had any sexual contact or sexually explicit messages like at all. And then out of nowhere, she's like, wow, I can't believe that crazy girl Merck. It's so mean when people try to out each other's sexual advances. Like, that's horrible. Like, I would never do that to you. And then we started to kind of chat sexually a little bit. And then obviously she leaked our messages immediately to Justicle's Discord server. I was like, okay, well, good one. It's funny because she deleted, like, I think she ended up leaking like some of these, but she deleted some of these messages. Like she deleted the message where she called out Merck. She's like, Merck came for you. No, not again. We've got to get away from crazy girls. I don't remember what this was, but she said, even if you did, who cares? It's shitty to out someone for making an advance at you, especially if it's someone you trust. But I wouldn't stress over that was so unnecessary. Well, Stephen, I have the best news ever for you. I am a trustworthy person, and I don't out advances. I was like, okay. But that's good bait, good bait. I give her, 7 out of 10 bait, 7 out of 10 bait. Not bad. However, The statement in Brooke's declaration have nothing to do with the video at the center of this. The video to which Brooke refers in her declaration is an unrelated video featuring Bunnell and a third party. So if you read the logs so Brooke, this girl was the only person who signed an affidavit as part of Pixie's case. And Brooke claimed that I offered to send her Pixie's video. So two things. One, I never sent her anything. Two, I didn't even offer to send her anything. Three, I made a joke about videos that I could send. But if you're reading what I'm saying, well, very explicitly, I'm talking about it's something unrelated, but it's a video of me eating somebody out. So it's not the subject of this complaint. That's not anything to do with any of the videos released relating to any of the stuff, but definitely nothing in this complaint. Okay? So the declaration, I don't know why they do this. It's just a fucking lie. I mean, that's the reason. But so they claim that that's evidence of me transmitting anything between me and the video that's part of the complaint. It's not. It has nothing to do with this. But that's the only one that's that they've signed an affidavit for. But good one. Is an unrelated video featuring Bunnell and a third party. Plaintiff played a significant role in exacerbating the harm that she allegedly suffered by posting a lengthy public statement and promoting the leaks on her Substack page. In that post, plaintiff falsely accused Bunnell of intentionally distributing pornographic content and using a proxy to widely distribute the video for self-promotional reasons. Nonsense. In reality, Bunnell was the primary target of the leaks. Plaintiff's false accusations and public narrative not only mischaracterized the events, but also amplified the spread of the video, thereby worsening the purported harm that plaintiff attributes to Bunnell. In that Substack post, plaintiff also indicated that she was planning to file a federal lawsuit against Bunnell. She then used her various social media accounts to advertise and promote her narrative. For example, on X and Blue Sky Social, she wrote, "I will be suing Destiny in federal court. Here's my story," and provided a link to her Substack. Plaintiff's commentary drew significant attention online and caused innumerable people to search for and download the video. Additionally, plaintiff and her friend, Lauren Dreeben Hayden, created a Give, Send, Go page to raise money to cover plaintiff's legal fees in the lawsuit. The fundraising page also includes a link to plaintiff's Substack post. To date, plaintiff has raised approximately $50,000 of her $130,000 fundraising goal. Plaintiff's public comments and fundraising efforts have led to more interest in the video. In her motion papers, plaintiff directs the court and the public to various websites where the video supposedly can be found. Without even filing her pleadings under seal, plaintiffs identified specific websites on which the video is available for viewing and or download, provided URLs to those sites, and even suggested search terms. And then this is a link to their own motion. It's fucking ridiculous. This goes to the legal standard of granting injunctive relief. So you have to show substantial likelihood of success on the merits, irreparable injury that will be suffered unless the injunction issues. The threatened injury to the movement outweighs whatever damage the proposed injunction may cause the opposing party, and if issued, the injunction would not be adverse to the public interests. So we just go through some of the legal standards on that. Argument 1, plaintiff is not entitled to injunctive relief. Plaintiff's inability to establish a substantial probability of success on the merits of her claims is fatal to her motion. A plaintiff's probability of success on the merits generally is the most important of the 4 factors a court must consider in issuing injunctive relief. If the movement is unable to establish a likelihood of success on the merits, a court need not consider the remaining conditions prerequisite to injunctive relief. Plaintiff has not and cannot make the requisite showing. So the first part is the court lacks subject matter jurisdiction. Plaintiff alleges the court has subject matter jurisdiction because her claims arise under federal law, namely 15 U.S.C. 6851. Cardi provides remedies for conduct occurring only as of the effective date of the statute. A court must not give retroactive effect to statutes burdening private rights unless Congress had made clear its intent, obviously. Indeed, a federal district court has held that Cardi cannot be applied retroactively to conduct predating the effective date of October 1st. In this other case, a plaintiff sought to amend her complaint to add a claim under Cardi for conduct allegedly occurring in March and April. In opposition, the defendant asserted that the law didn't go into effect until October 22nd. Let's just give an example. Another case where somebody tried this. Obviously, it didn't work. You can't do this. Here, Bunnell's sole transmission of the video preceded the effective date by nearly 6 months. In plaintiff's complaint, plaintiff alleges albeit mistakenly, that Bonnell transmitted the video to Rose on or about October 4th, 2022. Plaintiff's mistake is understandable. In a screenshot of the transmission, the date of the communication appears as 10/04/22. However, the date is reflected using the European date format, day, month, year, because Rose was communicating with Bonnell from a European time zone. Notably absent from plaintiff's motion is any admissible evidence that Bonnell transmitted the video after the effective date of the statute, because plaintiff is now aware that the actual date of transmission was in April 2022, nearly 6 months before CARD took effect. Because the date of transmission precedes the effective date of the statute, there is no federal question and no basis for subject matter jurisdiction. Accordingly, plaintiff cannot establish a likelihood of prevailing on the merits of her claims. The motion must be denied and the lawsuit should be dismissed. The court shall not exercise supplemental jurisdiction. This is just going through all the PI stuff. Oh, and then some of the other claims, because some of the other counts that they're suing for, so like sexual cyber harassment. I don't know how many of the elements, I don't think I meet any of the elements of this. This requires the transmission of sexually explicit material that 1, contains or conveys the personal identification and information of the depicted person, and 2, was transmitted with the intent of causing substantial emotional distress to the depicted person. To prevail on such a claim, a plaintiff must demonstrate that the material was transmitted with explicit intent to harm plaintiff. Further, the material must identify the plaintiff by name, postal or electronic mail address, telephone number, social security number, date of birth, or any unique physical representation. Here, plaintiff has proffered no evidence to demonstrate that Bonnell transmitted the video with the specific intent of harming plaintiff. Indeed, the record demonstrates just the opposite. Almost immediately upon learning of the leak, Bonnell took steps to protect plaintiff's privacy. If you're ever bored, and it's kind of funny, this is one of the things I've been staying up late, or I was a month or two ago, staying up late reading, is like if you read all of the underlying court cases they cite, these cases are fucking insane. Like most of these Doe cases are like plaintiff broke up with defendant, and then defendant tried to call them 400 times, and plaintiff didn't respond, and then defendant started like emailing or posting publicly like porn videos of them to try to, they're like unhinged. Like the defendants in these cases are legitimately fucking crazy, like schizo people. And it's funny because that's like all the underlying cases they cite, but it's, yeah. Almost immediately upon learning of the leak, Bonnell took steps to protect plaintiff's privacy. He engaged a specialized law firm at his own expense, sent takedown demands to numerous websites that hosted the video, and kept plaintiff up to date on his progress. Similarly, under Florida law, a claim for public disclosure of private facts requires the publication by the defendant of private facts that are offensive. Oh, I've seen some dipshit lawyer, penny lawyers on YouTube and Kiwi Farms talking about what it means to publish a video. And some people are like, oh, well, if it's a Google Drive link, then that counts as publishing. No, that's not what publishing means. There's not like a cutesy word for public. Like publish is when you make something available at large to the public in like a very obvious way. So publishing something on a newspaper, publishing this on like a public facing website, something to the effect of this. If you read some of the cases on this, there are things that even I was surprised didn't count as like publication for this public disclosure of private facts. Like one of the cases that they cited for this was a doe who, I think a guy, her ex, like had a video of them banging, and he like held the phone up at a bar and was showing like, 30 or 40 people at a bar. And even that didn't meet the element for publication. But like publication generally, it requires you to like, you have to publish this on a public website where people, it's not just like, but whatever. How much does this cost you so far? I don't know, probably it's too much. Probably like $40,000, $50,000, $60,000. Good use of my money. How much does it cost her? I have no idea. The way that the lady and everything is arguing, they almost seem like they're personal friends or family friends, so maybe they're getting like a discount, but I don't know. Who the fuck knows? Citing an underlying case, critically, the publicity given to the private fact must be more than mere publication. The fact must be made public by communicating it to the public at large or to so many people that the matter must be regarded as substantially certain to become one of public knowledge. It is not an invasion of the right of privacy to communicate a fact concerning the offender's private life to a single person or even to a small group of persons. Here, no large-scale publication by Bonnell occurred. The video was transmitted to one person on one occasion, or on one occasion to one person. Such conduct does not amount to publication as a matter of law, obviously. Further, plaintiff's claim for intentional infliction of emotional distress is similarly deficient. Plaintiff has not cited any authority for the proposition that a single private transmission of a video to one individual who is unaware of the plaintiff's identity constitutes extreme or outrageous conduct. On its face, the alleged conduct was neither retaliatory nor malicious. Indeed, plaintiff met Bonnell in person for the express purpose of making a sex tape together. They previously exchanged similar content with each other. The potential for distribution of their video, whether intentionally or not, was certainly within the realm of possibility. Plaintiff's purported outrage now is disingenuous at best. Plaintiff cannot establish irreparable harm. That's just going through irreparable harm standards, citing, again, what the judge said for the TRO. Moreover, the case authorities on which plaintiff relies to support a finding of irreparable harm demonstrate just the opposite. In each of the cases cited by plaintiff, the moving party established through admissible evidence that the alleged conduct was continuing or even escalating. For example, in Doe v. Constant, the defendant surreptitiously acquired nude photographs of plaintiff and distributed them on multiple occasions to her family, friends, colleagues, and her office landlord. The plaintiff demonstrated evidence the defendant was continuing to attempt to engage plaintiff without her consent, and that he surreptitiously captured several photographs of plaintiff using his cellular phone while she was testifying in the preliminary injunction hearing. In granting injunctive relief, the court concluded that this behavior, along with a cyclical pattern of escalating contact with plaintiff followed by disclosure, tends to show the defendant poses an imminent risk of dissemination of plaintiff's intimate visual depictions. Again, like all the underlying cases for this are the defendants are legitimately fucking unhinged. They're legitimately insane and unhinged people. Jesus. Plaintiff's reliance on Doe versus unknown party is similarly misplaced. In Doe, the court found evidence of defendant's continued campaign to harm plaintiff, including a pattern of practice of retaliating against plaintiff due to an ongoing custody dispute. In Diaz, the defendant, Tekashi69, a well-known rap artist, publicly posted sexually explicit videos of plaintiff on multiple online platforms for commercial and promotional purposes. Evidence demonstrated that the defendant continued to display and market the explicit content to promote sales of his music. The court granted injunctive relief accordingly. Here, there is no continuing conduct, let alone escalating conduct, to be enjoined. Plaintiff has submitted no evidence that Bonnell continues to distribute the video. Indeed, he has not. Bonnell transmitted the video on just one occasion over 3 years ago. Bonnell's never posted the video on an online platform, nor has he threatened to do so. Bonnell's taken no steps to exacerbate the harm. In fact, he's done just the opposite. Simply put, there is no ongoing conduct to enjoin, and therefore no irreparable harm to prevent. Plaintiff's own publication cannot form the basis for irreparable harm. Plaintiff's claim of irreparable harm is further belied by her own conduct. If a party has acted to permit the outcome which they find unacceptable, we must conclude that such an outcome is not an irreparable injury. If the harm complained of is self-inflicted, it does not qualify as irreparable. The case law is well settled that a preliminary injunction movement does not satisfy the irreparable harm criterion when the alleged harm is self-inflicted. Here, plaintiff exacerbated her own alleged harm. Before posting online about this lawsuit and her purported claims against Bonnell, plaintiff admitted to him that she was not publicly identifiable in the video, part of our messages, but for plaintiff's own public comments about the leak, she would have, for the most part, remained anonymous. However, on January 20th, plaintiff published a Substack post wherein she publicly identifies herself as the woman depicted in the video, a fact previously unknown to the general public, indicated that she was planning to file a lawsuit against Bonnell and falsely accused Bonnell of widely distributing the video. Plaintiff also created a Give, Send, Go page to raise money to cover her legal fees in connection with this lawsuit. Further, plaintiff used her social media accounts to advertise and promote her claims and solicit donations. And in some of her public statements, including in her own motion papers, plaintiff identified specific websites on which the video is available and provided URLs for those sites as well as search terms to find the video. Accordingly, plaintiff has not and cannot establish imminent irreparable harm in the absence of injunctive relief because any harm she allegedly suffered was largely self-inflicted. Requested relief is not necessary or warranted. So request orders 1 and 2, improperly seek to enjoin conduct that's not occurring. So stuff that obviously I'm not doing. Never published the video to any public forum. Haven't showed or transmitted it to any other third party. Numerous public comments about the suit and allegations against Bonnell. Further, despite plaintiff's numerous public comments about the suit and her allegations against Bonnell, she seeks to enjoin him from defending himself in the same online community. Specifically, plaintiff attempts to prevent Bonnell from using or publicizing her prior messages with him, many of which cast serious doubt on plaintiff's reported claims. Plaintiff's request is particularly unwarranted, given that she was the first to publicize the party's private communications. For example, in her January 20th Substack post, plaintiff published a self-described evidence log wherein she links to 3 private communications between plaintiff and Bonnell. Plaintiff's attempt to muzzle Bonnell while maintaining her ability to speak freely about the case is fundamentally unjust. Plaintiff admits that she possesses no evidence of spoliation. Critically, plaintiff has not yet served Bonnell with any document requests in this action. Spoliation is a discovery offense, so issues surrounding alleged spoliation should be resolved during discovery. Due to plaintiff's failure to serve document demands, she has no basis to assert, let alone evidence to support her contention that evidentiary material has been destroyed or otherwise lost. No such evidence of spoliation exists, and for good reason. Bonnell has preserved all evidentiary material consistent with his legal obligation. In the event that the court does issue a preliminary injunction, we're asking for a $500,000 hold, I think, just in case I suffer damage from the injunction or something, I think. So, but hopefully they deny it, I guess. I don't know how these usually go or what. I guess but obviously I'm the respondent here, so I would hope that I would win this thing. I don't know when they have to have it decided by, but for us, if this gets granted, is it over? No, we still have to go through the whole discovery phase. Basically their whole thing is what they're praying is that like I basically sent a whole bunch of like her material to other people and it just hasn't come out yet, and they're hoping that somehow they can like uncover this somewhere, but I haven't done this. They have no evidence of this, so it's just this is like so the goal is to just like try to dig through as much of my shit as possible, and then who knows how much more they want to fucking leak because they enjoy doing that, I guess, so far. And then once they've found nothing, then hopefully we file for summary judgment, and then at the very least that prima facie that first complaint dies, or the first cause of action would die because they failed to state a case because they have no evidence of anything that happened within statute range. And then the case would get dismissed because of lack of subject matter jurisdiction, because it would no longer be in a federal court. And then if they want, they can, they'd have to refile, I guess, in Florida court, but then they have to drop that federal thing. So it's just for like sexual cyber harassment or something. Like, are you expecting any real money from this or just a public retraction / apology? No, I will not get any money from this. And I will never get a public retraction or apology. My guess is she's probably realizes that she doesn't have like a huge streaming YouTube career thing, and she's just trying to cash out before, I guess, leaving or something. I don't know. Who knows? But fun times. I feel like them just having it dismissed and not refiling might be the worst outcome. What, for them or for me? Well, I'm okay with it getting dismissed. I don't give a fuck. How long do you think this will go on for? I'd have to go back and look. I don't know fucking federal rules of civil procedure or any bullshit. So I wouldn't be able to tell you. I don't know if you can file for summary judgment before the discovery phase is over. So we either have to wait for the full discovery phase to end, which I'm sure is on the court schedule somewhere, and then you can file for summary judgment, or if you're allowed to file for summary judgment during the discovery phase. I just don't know what the answer to that is. Is there a date for when the PI is being heard? I don't know if PIs are both parties show up for a hearing or what that works, but I mean, the them never refiling means that there's always an open issue about this case that people might still latch onto. I mean, people will anyway. It doesn't matter. So it is what it is. Good times. Fun memes. Have you actually been in the courtroom yet? And actually, I don't think we ever have to go to an actual courtroom until like probably the day of their trial. I don't know when you're supposed to physically, or when the actual like parties to a case and not just the representation has to go to a courthouse. I have no idea. What's your best case scenario? Mine is having it dismissed at summary judgment, I guess, and then Good times. Did you see a 2-year-old citizen got deported? Nope. The real meme for this would have been if, I think I'm in the same district as Eileen Cannon, right? As if the case would have gone to her. Whew, that would have been extra spicy. Quick Hassan meme from the video earlier. He had encyclopedic knowledge of Sam Hyde in 2021, a whole year before the fight.
Can you admit at this point that when Sam Hyde did that video, that it was very funny?
No.
I'm friends with you. That was very funny.
I always, like, I had no idea who the fuck this dude was at all. Like,
I'm gonna kill you! He was doing
at the time,
yeah.
I didn't know who this guy was, right? And I'm like, why is this fucking ugly freak, like, yelling about me all the time? Like, I just didn't even know.
Who the fuck is Sam Hyde? Sam Hyde is some fucking 4chan troll that, like, gained a little bit of prominence and had, like, a Adult Swim show for, like, a week and a half. And everyone thinks that he's a fucking brilliant actor or whatever the fuck. He just sucks. He literally just sucks. I like comedy. It's just like some fucking random has-been who dumbass 4chaners still self-report on every time they bring him up. He had like 3 fucking funny memes and that's it.
Can you admit at this point?
Damn. All right, well. I love you guys. It's been fun. I'll see you tomorrow in Detroit. Check out my YouTube community post section if you're looking for a place to buy tickets. In case you're not there. Or you live near there and you haven't got a ticket yet.